really willing to get in touch with our project. This is a new funded project that's been running for more than 3 years right now, 3 years and 5 months, to be sincere, and we are just in the final part of the project. So we are disseminating lots of its contents. And for those who are really willing to interact with us, we will be delighted to do so. We are creating a lot of very interesting outcomes that could be useful for you. But today we will specifically focus on one thing that we really consider that it's very important to do. That is that we are just trying to create some materials that could serve well to all those who are willing to gain quite good knowledge of some of the most important parts of the GDPR. So let me share my computer. This is a presentation that was prepared by me, myself, and my colleagues from the Brugge University in Brussels. So I really thank Alessandro and Carlota and all the staff there for being so kind to help me with this and prepare that. So let's start with a few notes about what we are doing today. As some of you know, maybe most of you know right now, the GDPR is really a key regulation in the EU arena. That it's the main tool that we have right now in order to regulate whatever has to do with data. And so it's quite important that we know how it works and what are the fundamentals and the ideas that we got in there. Of course, the GDPR is a very, very extensive tool that really contains lots of different provisions, and we cannot really focus on all of them. So today we will mainly focus on 3 main aspects. One is the philosophy that's in the GDPR, why it was created, and what's the rationality behind. And then we will go for the principles, the main principles that, in my honest opinion, could be considered as a kind of the most important guidelines on how to process personal data. And finally, we will go to the rights of the users. That is a third essential point in there. So I would just be starting with the first slide. And the first slide is mostly about what the GDPR is. So the GDPR is a regulation, meaning that it is directly applicable in all member states of the European Union. So it's totally related to the protection of natural persons. It does not apply to kind of a non-natural persons, meaning companies and so on. And it's intends to contribute to the completion of an area of freedom, security, and justice, and of an economic union, to economic and social progress, to the strengthening and convergence of economies within the internal market, and to the well-being of natural persons. So it's really a kind of regulation that tries to balance somehow the need to protect people and their rights regarding processing of their personal data. We're just trying to keep you all protected somehow against any possible harm that might be caused by an unlawful processing of your personal data. But at the same time, we are trying to conciliate that with a kind of a use of those data for some essential purposes that probably will be a very nice application in the future. At the present moment, for those who are not aware of that, there are some other regulations that are in the making, mostly the A Act, the Artificial Intelligence Act, the Data Act, and the Data Governance Act. So we will have a lot of different regulation that will apply to everything related to data protection. But the philosophy that is in there is always more or less the same. We are willing to share our data. We are really willing to use those data in order to build a better world in the future at the EU level. But we want to conciliate that with the protection of the human rights and the rights that all EU citizens share. So the GDPR is mainly about processing of personal data, not in domestic activity, even though domestic activity is usually interpreted in a very narrow sense, meaning that most of the processing of personal data is usually covered by the GDPR. And of course, one of the reasons why we created this regulation is because of the imbalance in power between the different agents that participate in the digital arena, meaning that most of us are not as powerful as some companies are. So the regulation is aimed at protecting us against this kind of imbalance of power. So it's providing us much more power to negotiate what can be and cannot be done with our data. So that's really what we got there in the GDPR. GDPR, as I was saying, mainly refers to personal data. Personal data means any information relating to an identified or identifiable natural person. That is called the data subject. If you wonder what identifiable natural person means, well, it's well defined in the regulation Article 4. It states that an identifiable natural person is one who can be identified directly or indirectly, in particular with reference to an identifier such as name, identification number, location data, etc., etc. When we got this, well, we got, for example, what we call pseudonymized data. Those are data that really somehow connected with the...
One second, Inigo.
Yeah.
It seems you are not sharing your screen.
Oh, sorry.
You mentioned so.
Yeah. Sorry, I thought I was doing so, but I will go for that. Yeah. Oh, yeah, you were right. Yes. So the point is that I was just saying that in general, when you... Okay, I think that now you should see that. So yeah, now we got it. You can see that, right?
Yes,
right
sir.
Now.
Yeah, perfect.
So yeah, thank you so much, Monica. So the point is more or less that when you are using what we call pseudonymized data, those are still personal data in the sense that you can connect those data with someone, with an identified person. Instead, when we talk about anonymized data, those are data that cannot be linked to someone, to a natural person any longer. Of course, there are a lot of discussions on whether some kind of data are pseudonymized or anonymized data, but in general, if you could trace that condition, and you don't really need to introduce really, impressive measures or do quite extraordinary actions to trace the linkage, we are considering that those are anonymized data. And but if we are not dealing with such type of data, in general, the GDPR is applicable. For those ones who are willing to have a much better understanding of the difference between pseudonymized and anonymized data, I encourage you to go to our webpage in Panafit, where one of our partners, the ULD, has really developed an impressive report about the differences between all these types of data and the techniques that can make anonymization more or less quite a reliable thing to do. So that's what I can tell you in advance. So, well, personal data means, as I was telling, some information related to an identified natural person. It is not important whether it is really truly or not. I mean, if you say something that is really terrible about someone and moreover it is just a lie, that is a personal data. Indeed, it's information that you give. Of course, that could be called misinformation, but misinformation is something that we should consider information in terms of the GDPR. And this is precisely why we got a principle that it's accuracy, and we have a right such as rectification in the GDPR. Those are there in order to protect you against misinformation, so as that the principle is telling controllers that they should not process information that is not accurate, and it's and the GDPR is providing you with this right of rectification, so as that you could go there and tell them, please rectify that because this is not working well. If this kind of misinformation were not considered personal data, then we could not really, apply for this kind of rectification. So it's very important that we consider that it is. It's not so important to in order to consider whether something is personal data or not, if it were obtained for the individual or third parties, or if those were inferred. Because sometimes, you know, those controllers don't really have one of your data, but they could more or less, you know, make a guess. This is what we call an inferred data. An inferred data are also personal data in the sense that they give information about you. So in general, the concept of personal data is very extensive, okay? And we really have to live with that. I mean, we cannot really restrict the concept. For example, it could bring a lot of different issues regarding genetic data that, as you know, it's all those data that relate to different people who share a kind of common heritage, a common DNA, and this could be considered, in my opinion, as personal data of all the data subjects involved in that. But this is a quite hard discussion, and I will not get into that at this moment. So then we have what we call data of special categories. This is a quite a specific type of data. In general, those are mostly personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, identity membership, and the processing of genetic data, biometric data intended to uniquely identify a natural person, data concerning her, or data concerning the sex life or sexual orientation of a natural person. All of those are considered usually data of special categories. So the processing of this type of data is specifically prohibited. Okay, so if you are not aware of that, whenever you are trying to process any of those data, you should consider that this is vetoed by the GDPR. There's a kind of ban that it's included in Article 9.1 of the GDPR that just states that you cannot process those data. However, Article 9.2 of the GDPR introduces some exceptions, some circumstances that could make it possible to process those data. So if you are willing to do so, one of the things that you really need to do is make sure that one of these exceptions applies. There are lots of different exceptions. There are 10 indeed, such as, for example, consent, or, for example, the idea that data have been made manifestly public by the data subject. For example, if they have introduced them in a kind of a Facebook page or something like that, and some more. But in general, you should consider that this only allows you for avoiding the veto that is included in Article 9.1. It doesn't mean that you can directly process those data. So when you're in a point, and you have arrived into this moment when you more or less have no vetoes, or you are not dealing with the special categories of personal data, then supposedly you could start processing the data. But you could only do that under some certain conditions. This is precisely what we call the principles that are somehow like the soul of the GDPR, because it's telling you what you have to do if you are willing to process data, okay? So those principles, if I remember it well, they are in Article 5 of the GDPR, are more or less 7 principles. And the first of them is maybe the most important, or one of the most important in my opinion. It's what we call the principle of lawfulness, fairness, and transparency, which means that those data should be processed lawfully, fairly, and in a transparent manner in relation to the data subject. Then we have the principle of purpose limitation. This principle just states something pretty simple to understand. It just states that if you are just gathering data, you should use them for the purpose for which you were gathering those data. So data in general should be collected for specified explicit and legitimate purposes and not further processed in a manner that is incompatible with those purposes. So it's very, very simple. Just keep in mind that whenever you are processing data, this processing should be strictly connected with the aims, with the goals that you were willing to reach from the very beginning, and you cannot really use them for any other purposes. Then you get another very important principle, that is data minimization. You should only process the data that you really need to reach your goal, and nothing else. I mean, if you cannot justify that you are processing some data, you should not be doing so. Data minimization also means, on the other way around, that if possible, try to use those data that compromise the situation of the data subject, meaning that if you could use pseudonymized data instead of personal data that have not been pseudonymized, that's much better that you do so. And if you can use anonymized data, that will be even better. That will be perfect from the perspective of the GDPR. So the point is always this: try to use as few data as possible, and try to use them in a format that really, works well with preserving the situation, the intimacy, the power that the subjects got over the data. So then we got the principle of accuracy that I've already mentioned before. Accuracy means that that data should be more or less kept in an accurate way. This means that the controller needs to make sure that if the data are accurate, and so sometimes the controller will have to verify, update them, and make sure that they are really accurate. And if needed be, some data should be erased or rectified without delay if we understand that they are not accurate. Then we have another interesting principle, that is the storage limitation principle. That means more or less that those data shall be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. So the idea here is that in general, you should not really conserve or storage data for any longer than necessary. In principle, lots of us are always, looking forward to preserving some data because we sometimes consider that they could be useful for the future. This is, for example, is quite common in some professions such as journalism. Journalists are, sometimes reluctant to erase any data because they consider that those are valuable and they could serve them well for the future. Well, in general, I dare say that this is not really a good idea. And so the point is that whenever possible, you should not keep your data longer than necessary. So that's what the storage limitation principle says, that somehow it's clearly complementary to the minimization principle. And then you get into integrity and confidentiality that work together. And those principles state that data shall be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage, using appropriate technical or organizational measures. That's integrity and confidentiality. Those are important principles because they introduce somehow the weight of the preserving the data on the shoulders of the data controller, who should be the ones that really are protecting those data. Okay, and one very important thing is the principle of accountability. This is essential because what the GDPR is doing is that, in general, it is the controller who has to demonstrate that they have done whatever possible to ensure that all these principles are really, taken into account and everything has been done according to this principle. So that's more or less what we have as such in the arena of the principles. That's one special principle that I was telling you before. It's the first one. That's maybe the most important one, in my opinion, because it's really related to some essential issues that we have to face. First of all, as I was telling you, this principle is called a lawfulness, fairness, and transparency. Well, fairness and transparency are important issues in the sense that transparency is quite necessary when we are processing data. In general, this is not so difficult to deal with, but in some concrete circumstances and scenarios, especially when you're, for example, using an artificial intelligence tool that is based on motor learning and so on, well, we all know that in some cases, there are some issues related to transparency. Well, for all those ones who are really willing to develop one of these tools, I dare always remember that transparency is a principle that applies to personal data processing. So they should always be aware that they should give a good answer to this requirement of transparency. The AI Act indeed will probably enforce this requirement, and we will see that in the future there will be lots of certifications about this kind of issues and see how it works. There's also another thing that it's fairness, that it's also much related to some of the most important requirements about artificial intelligence. For example, fairness is about the way in which some tools work, meaning that, for example, if you are building an artificial intelligence tool, you have to make sure that it's not creating bias and discriminating in an unfair manner those who will be the object of the decision, something like that. So fairness is also important. But the most important part, in my opinion, is what we call lawfulness. Why is that? Because lawfulness is the real key point and the very beginning of everything. You can only process personal data if you get what we call a lawful ground or legal ground for lawful processing. This is quite well expressed in Article number 6 of the GDPR. There you can find the six main grounds for data processing. Each ground is a kind of reason, of justification to process personal data. Those 6 legal grounds are consent, as we all know, the necessity for the performance of a contract to which the data subject is a part, the idea that the processing is necessary for compliance with a legal obligation to which the controller is subject. A processing is necessary in order to protect the vital interest of the data subject or another natural person. Processing is necessary for the performance of a task carried in the public interest or in the exercise of official authority vested in the controller, or processing is necessary for purposes of the legitimate interest pursued by the controller or by a third party, with some exceptions. So more or less, those are the 6 reasons why you could process personal data. So if you, for example, are trying to process data of special categories, data that are more sensitive, first thing that you should do is to try to find an exception to the veto in Article 9.2, and then you should find a legal ground to start the processing of those data. And these are the legal grounds that you have. More or less, all of them have the same weight. The only exception, most probably, is vital interest. Vital interest only applies when all the rest of the legal grounds don't seem to be applicable. Okay, so that's quite, I mean, the type of legal ground that usually we are not using. But for the rest, it's more or less always the same. And indeed, one of the things that really changed from the previous directive to the GDPR, I think, is the kind of mindset that really has made of consent become not really the most important and of the legal grounds, but one more, and not really something that we should prefer to the others. Indeed, and in practice, a consent is not always so reliable as a legal ground. And in my honest opinion, is something that we should try to avoid so many ways and in so many circumstances, such as, for example, clinical trials. I'm always quite unconfident with using a consent as a legal ground in case of clinical trials. But this is more or less what we got about the legal grounds. Of course, sometimes it might happen that it comes to you a situation that is really worrying. That is that, well, you are willing to use the data or reuse the data for an operation that's a little bit different to that kind of operation for which the data were obtained initially. So in this case, it's there's something that you should always keep in mind. It's very important to understand, to guess whether this new use is compatible with the first one, okay? And the GDPR, in this sense, will probably allow you to go on with this processing if it is compatible, and will tell you that you should find a new legal ground for the processing if it is not compatible at all. So how do you know that? Well, in theory, it's quite simple. The GDPR includes a compatibility test in Article 6.4 that really introduce some kind of requirements to consider that the users are compatible. Not all of them are so conceptual, in my opinion. For example, it starts by talking about link between the purposes for which the personal data have been collected and the purposes of the intended for the processing. That makes perfect sense. Also the context, and the relationship between the data subjects and the controller, the nature of personal data, and the possible consequences of the intended for the processing for data subjects. If the consequences could be, quite damaging to the data subject, well, it's more difficult to think that they will be compatible. But also, they introduce the existence of appropriate safeguards, which may include encryption or pseudonymization. In my honest opinion, these last ones don't really have to do with a kind of conceptual connection between both users, but have to do with the consequences that may happen to the data subject. So the idea here is that in order to think that some users are compatible, it should happen that there is a kind of, a conceptual linkage between them, but also that the data subject could more or less anticipate that those data could be used for these other different additional purpose, and that he will not be suffering a kind of real damage if just this compatible use is done and we really process those data. So that's what we have. And then we have something that is very, very interesting. One of the things that really, sometimes some people dream about that, because it's something that is pretty clear. That's what we call the processing for research purposes. This is very important for all those ones who make research in the EU arena. Well, I just can tell you that we have an article in the GDPR. It's much related to the limitation purposes principle. It's just a kind of really an exception to this principle, because it just states that for the processing for achieving purposes in the public interest, scientific or historical research purposes or statistical purposes shall, in accordance with Article 89.1, not be considered to be incompatible with the initial purposes. So what this article is really stating is that in principle, the GDPR assumes that if you are using those data for this kind of purposes, such as, for example, scientific research, this new use, this new processing is compatible with the first one. The aims of both processings are compatible, and then the legal ground that you use that served you well for the first processing will also serve well to justify the following, the reuse of data. So the following process. So that's more or less what we got in mind. Of course, this is not provided for free, and we got something that is called Article 89. That is more or less saying that if you are willing to do something like this, you will probably have to introduce some safeguards to to prevent that any damage could be caused to the data subject. And this could include, for example, pseudonymization. That's very typical, but also separation, for example, between the different teams, research teams that are part of the research. For example, if you're in a clinical trial, it would probably be some differences between the ones that are there and the ones that are processing the data for other purposes, okay? So, and also there's something else that we must bear in mind. There is that Article 9.4 states that member states may maintain or introduce further conditions, including limitations with regard to the processing of genetic data, biometric data, or data concerning health. This means that even if we are willing to use this clause in general to say, oh no, I just want to use those data for research purposes, so I just don't need a new legal ground or anything like that. Well, this is not so clear in the case of personal data. That has to do with or some type of personal data, such as genetic data, biometric data, and health data, because in those cases, member states can make some exceptions to the processing of those data. So in general, one will probably have to take a look at the national regulation and see what happens. For those who are not aware of that, just a little excursus, the GDPR is a regulation, but indeed it provides a lot of exceptions to what it's stated in its clauses. Meaning that at some points, it's somehow a kind of a mix between a regulation and a directive. And member states could really fix some concrete issues according to the national interests or preferences or whatever. So just to end with this first part regarding how the GDPR is and how the principles work, I just wanted to make some points on three interesting things that maybe you could keep in mind that, in my opinion, have not been so well solved by the GDPR. One is that, for example, the GDPR is mainly built on the idea that data subjects and data are something somehow individual, meaning that you're a data subject and you get your data. Of course, this is not always the case because, for example, there are some data that could be shared by different data subjects. Oh, a nice example is a photograph group. There could be lots of people there in that group. There's only one photograph. So in principle, it's all those ones who have been in the photograph are data subjects. When we have to deal with that, we usually just ask everyone if they are willing to share the data or not. And if someone is not willing to be part of that, we somehow mask their faces or anonymize their own photo. Even if it's very difficult to anonymize that, and lots of people could really know who's that one, just checking a look to the rest of the people in the photograph. Anyway, more or less, we just live with that. Another thing that we have that's a little bit more complicated is the idea of genetic data. As you know, members of a family, the relatives, for example, share some genetic data, meaning that if I know something about someone in a family, I might know something or suppose something about some of the relatives. Of course, this is very typical in the case of twins, but also works quite well with siblings and also with parents and children and so on. And in this case, it's quite difficult to know how to do the things because you cannot so simply erase some part of the information in the equation. And sometimes, for example, a daughter would like to know some genetic data, but only the father, or they're only in the clinical records related to her father or something like that, and we just have to start conciliating different rights and so on. It's not so easy to do. We are not really in a point when we have already decided whether all those relatives will be data subjects of those data or not, or how this could be faced. We don't have a good answer. The GDPR does not deal with deceased people. This is a second weakness, in my opinion, because it's only about it's only about natural person, but it's not really something that comes from the philosophical corner, just like saying that, well, as they are there, they are no longer persons, so they're not personal data, and we are not dealing with them. No, it's just because they just decided to leave them apart, and they are not regulated in the GDPR. But this could be a huge weakness in the future, because in some years there will be much more data coming from deceased people that really affect us, that data from alive people. So that's something that maybe we should reconsider. And finally, the GDPR does not really deal with the issue of commercialization of data. I'm not saying that it is not really true that the GDPR somehow bans commercialization of data. In principle, data protection is based on the idea of rights, on personal rights, and everything that has to do with data has to do with rights. And this is good, in my opinion. I mean, works quite well. But we all know that in practice, sometimes we are somehow exchanging data for services. This is very typical, for example, when you are only allowed to get into a kind of a page or whatever, if you just, or you are given the possibility to give some of your data, to reveal, to process some of your data in order to avoid, for example, paying for the access to a web page or to a journal article or something like that. That's something that somehow is happening. And this is outside the logics of the GDPR in so many ways, but it's happening in real world. And I think that we will have to deal with that. I'm pretty sure that this probably will happen with the approval of the Data Act and the Data Governance Act, that some things will be somehow regulated in some other ways, but we will have to wait for that. But I can tell you that from the perspective of the GDPR, commercialization of data makes no sense, not in any way. We are just thinking about people sharing personal rights somehow, or providing access, but again, something like a kind of money or anything like that. So commercialization is not there. Okay, so we are now entering in the last part of this presentation, that is mainly related to one of the most important parts of the regulation. That is what we call the data subject rights. Data subject rights are essential because it's what you really defend you against any kind of break of the principles that controllers are supposed to adhere to. Well, what happens if they are not doing so? Well, in that case, you should be aware that you get some rights you could always appeal to. And those are included in the Chapter 3 of the GDPR that provides this set of rights that should serve you well to protect yourself. All of them got their specific details and issues, but they share some general features concerning the transparent information, communication, and modalities of exercise pursuant to Articles 12, 14 of the GDPR, and I will try to explain you what are these common features. First of all, the controller must always provide information that is correct and comprehensive. So the point is that in general, the GDPR includes a specific mandates. And I dare say that the control is only accepted from this obligation whenever the data subject has already that. I mean, you don't have to be reiterative. If they already got it, you don't have to give them. Otherwise, you will have to provide the data subject with certain information, such as, for example, the controller's identity and contact details, the purposes and the legal basis for the processing, the chance for data to be transferred outside the EU, the data retention period, the entitlement to the data subject's right, and the existence of automated decision making. Usually, whenever someone is asking you for your permission or is just informing you that your data is being processed, has to include all this information. Okay, I was telling you, the only exception is when the data subject already got it. If those personal data are not directly collected from the data subject, if you are the data subject from you, then the controller should also inform you that what is the source of this information and the specific data that they plan to process. Because sometimes it might happen, for example, that you provide your data to someone, but it's a totally different controller who is willing to process those data, which is not impossible. It's just that a session of data has happened and someone else is holding your data. But in these cases, this new controller has to provide you some information about that. So the second common feature that they'll have is that the language of the communication between the controller and the data subject must be understandable to the average person and provided in writing, unless the data subject requests otherwise. So this means that more or less the information should be understandable for the data subject. There's a minimum requirement, but for example, we are always explaining in Benefit that one of the things that happen is that the controller should make sure that the data subject is capable to understand the kind of information that is being provided. For all those ones who have worked in the framework of healthcare, they perfectly understand what we mean, because that is more or less the standard that's applicable to healthcare. I mean, we always tell the one who is informing that the patient should be able to understand all the key points that have to do with the decision that they have to make. So that's more or less the same idea, that should be understandable to the average people, but if possible, or if the data subject is not the average people, maybe the controller should make a special effort. Then we have a third common feature, that is the controller must inform about action taken following a request to exercise the data subject's right in a timely manner. Well, this means that if, for example, you want to appeal to your data portability data, you want to check your data, well, at that moment, the controller should give you some information about the actions that they will take in order to face your request, and they should do that with undue or excessive delay. Okay, so that's more or less what it's common to all of that. The fourth is that the controller can refuse a data subject request if the request is manifestly unfounded or excessive. For example, if you are continuously requesting your data, access to your data, and you do it every month or every 15 days, you are asking for that. Well, they could say that, but it makes no sense, and I will not do that. And also might also happen if, for example, the controller knows that the data subject has no intention to exercise the right or repeatedly submit the same request, more or less what I was telling you before. So might also happen, of course, if the controller has some doubts about the identity of the person who's asking for those data. If they got doubts, they should justify why they have those data. They should ask the person who is asking for example, for access, why they are doubting, and if the one who's asking for those data is not really providing new evidences, then the controller should not provide it. So, and finally, the exercise of each data subject's right must be free of charge. This is important, of course, because it has to do with equity, and everyone should be able to exercise those rights for free, if possible. However, there are some exceptions, such as, for example, when the controller is able to prove that the request is manifestly unfounded or excessive. Okay, but it should be the controller who has to really demonstrate that. And then we are going to get to some of the rights that we have. Let's start with the right of access. That it's one of the most important rights, in my opinion. The right of access is mentioned in Article 15 of the GDPR, and it provides the data subject with the chance to ask the controller whether he's processing his personal data or not. If this is the case, the data subject can access to the personal data and to some information, some very important information that includes the following: the purpose of the processing, the categories or personal data concerned, the recipients, the recipients, or categories of recipients to whom the personal data have been or will be disclosed, the data retention period, all the data subjects, right? The origin of those personal data, because sometimes, as I was showing you, they have not been collected from the data subject directly, the existence of automated decision-making, and this includes profiling, by the way, and the existence of all the safeguards taken to eventually transfer personal data outside the European Union. So you can really ask for all this information, okay? If you will be provided all this information if you are asking for your right to access. And what happens when you just start asking for this access? Well, the GDPR states that upon the data subject's request, the controller must provide him with a copy of the personal data being processed without charge. If the data subject asks for any additional copies, then the controller could ask for a reasonable fee based on administrative cost, but the first one should be for free. When the person, of course, with the only exception that I was mentioning before, I mean, if it's abusive, it makes no sense, then the controller could say, I'm so sorry, but he's really, this is abusive. He's asking for this copy every month, for example, or he's, I don't know, if he's doing something really absurd with that, or well, it should be a question of thinking about the concrete case. Then there's something that might happen when you appeal to the data of access. It might happen that the data, your personal data, includes information about all the people. So when you are in such situation, the controller is not always obliged to provide you this data, because otherwise they will be unlawfully processing personal data of third people. So in this case, what they have to do is to balance, to try to balance between the data subject's right of access and the third party's fundamental rights. Okay, so that's quite important. So the controller more or less might conceal data that could negatively affect other people, such as blackening selected information. It's one of the things that could be done. So it's more or less up to the controller to solve such situations in a way that really works better for all the people involved in such situation. And finally, the GDPR does not prevent a person from potentially acting on behalf of the data subject, but you have to prove that, for example, through a power of attorney. That's one of the things that can be done. Then you get the right to rectification. Right to rectification is important. I told you before. In general, we are perfectly able to rectify some information that misrepresents reality. However, here you get a lot of, let's say, some doubts. First, when it's objective and factual data, no problem at all. For example, the spelling of a name, you can just ask for the change, and that's all. And sometimes it might happen that we are thinking about objective data, but the controller might suspect that that the data subject is providing false data about themselves. For example, if someone comes to you and wants to rectify the age and they are saying, I'm not 62, but just 36, you could say, well, I got the suspicion that you are not really telling the truth. And in those cases, you are not obliged to rectify that. You have to make some consider why, or more evidence to the data subject. But in general, with objective and factual data, we tend to believe what the data subject is saying, especially when those data do not benefit them. When we are talking about value judgments and that are fact related, such as a personal evaluation of an employee, controllers might be more reluctant to change what they got. So in that cases, they must perform a balancing test between their freedom of expression and the right to rectification, and see, depending on the result, they should rectify it or not. Okay, so whatever happens, and during the process, in general, the controller should restrict the data processing when verifying the accuracy of the information. And this means that no one temporarily could process them. Then we go to the next one, right to erasure. That is very, 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 very popular, because this right to erasure gives the data subject the right to have the controller delete in total or partially his personal data without undue delay. So it reflects quite well the data minimization principle, meaning that, as I was telling you before, the data only be processed when it is necessary. Only works very well with the storage limitation principle, of course, because they will not be storage longer than necessary. The right to erasure applies in some concrete scenarios. First, when the personal data are no longer necessary for the purposes for which they were processed, when the data subject withdraws the consent and there is no other applicable legal ground. I didn't tell you before, but sometimes you could use different legal grounds in order to process personal data. It's not really said anywhere in the GDPR that you can only use a legal ground. So sometimes it might happen that, for example, you use as a legal grounds for the processing consent and public interest. In those cases, if the data subject withdraws the consent, you don't have to proceed with the right to erasure because there's another applicable legal ground. So it's you don't have to do that directly. So the third possibility is that the data subject objects to the processing and there are no overriding legitimate grounds for the processing. The next one is that the data have been unlawfully processed. There is a legal obligation to erase the data laid down in the EU or member states law, or the personal data have been collected concerning the offer of information society services to children. In all those cases, when this right to erasure applies, personal data must become unusable, meaning that neither the controller nor any other party can process them. This could be done in a very, very different ways. For example, you could just erase it all. If they are in a kind of hardware format, you might destroy it physically. So it's up to the controller to take the appropriate measures to reach that goal. So nobody but them which really deciding how. And there are some exceptions to the right to erasure that make perfect sense, because sometimes really data must be kept, no matter whether what the data subjects. It's all about that. For example, in the case of healthcare, you know, those who are on there, you know that lots of regulations on this concrete field ask the controllers to keep the records for some time, like 5 years usually. Well, if the law is saying something like that, then the right to erasure does not apply. So this is just a good example, but indeed there are several exceptions, including when the data processing is necessary for exercising the right of freedom of expression and information, complying with a legal obligation of data processing or for the performance of a task carried out in the public interest or in the exercise of official authority by the controller, reasons of public interest in the area of public health, achieving purposes in the public interest, scientific or historical research purposes or statistical purposes, or the establishment's exercise of or defense of legal claims. So you get a lot of reasons why you could tell, if you are the controller, you could tell the data subject that those data cannot be erased. And indeed, in some cases, you are really obliged not to do that. Okay, so just take care with that. Then there's a kind of right to restriction of processing. This right is mentioned in Articles 18, 19 of the GDPR, and it means that the data subject has the right to temporarily restrict the processing of his personal data. There are 4 reasons for a data subject to make a request for restriction, and those are: first, the accuracy of the personal data is contested. As I was telling you before, why you make this research and see whether those are really accurate data or not. This processing should be restricted. The second is that the processing is unlawful. Of course, if processing is unlawful, you cannot go on with the processing. The data must be kept for the exercise of defense or legal claims. This means that if you really need to keep them for those purposes, then restriction applies, and you cannot process those data for purposes that are incompatible with the exercise of defense of legal claims. And then a decision is pending on the legitimate interest of the data controller prevailing over the interest of the data subject. What does this mean? This has to do with a legal ground. That is what we usually call legitimate interest. Sometimes it happens that someone is willing to process your data, and they just show that they've got a nice legal ground. That is what we call legitimate interest. For example, a company will just be willing to process your data because they consider that this is good for them. That's really, they got a legitimate interest to process those data. But of course, it might happen that some of you are not so convinced and are not willing that this company is processing your data. In those cases, we need to perform what we call a balancing test that is performed by the controller, and they have to balance both different interests. Well, while this is being done, it's perfectly possible to appeal to the right to restriction of processing. And it's pretty clear. If it is so doubtful whether the legal ground applies or not, it makes a sense that we don't proceed to the data processing to try to avoid that we are doing that without a proper legal basis. The methods that you could use, that a controller could use to restrict the processing, well, there are a lot of different. For example, they can restrict this kind of processing. For example, I don't know, making them unavailable to users or removing them on a temporary basis. So the aim more or less will always be the same, that the information is not being processed so as nobody is getting access to this information. Of course, the only thing that you should not do, the only processing that is really available and could work is a storage, because if you don't go on storing those data, the data will not be restricted, but will be erased. So you will not be able to recuperate those data, and that makes no sense. But while the restriction is pending, personal data can still be processed under some circumstances. One is that the data subjects just provide consent. The other one is the establishment, exercise, or defense of legal claims. The third is the protection of the rights of another individual or legal person. And then, for reasons of important public interest of the EU or the EU member or an EU member state. In all those cases, the controller must communicate the restriction of the processing to its recipient, for whom the personal data has been disclosed, unless this proves impossible or involves disproportionate effort. This means that sometimes the controller or a controller has given the data to third parties who are the recipients, and sometimes it happens that the data subject has no direct contact with them. So the idea is that any controller who has provided the data to third parties should make them aware that there is this kind of restriction, so as they could also restrict the access to those data. And finally, the controller must notify the data subject before the restriction of processing is lifted. Well, we are just arriving to the last rights, some of the last ones. First is the right to data portability, one of my faves, because it's very important and it's essential for something as simple as changing your data from a company to another. Why? Because Article 20 of the GDPR tells that right to data portability allows the data subject to ask the controller to receive his personal data or transfer those data to another controller. So for example, if you are changing your data provider, your cell phone or whatever, you could always ask them to receive your personal data, in this in a quite concrete format, I would tell you now, or ask them to transfer those data to another controller. So, of course, the transfer of the personal data from a controller to another will depend on its legal, technical, and financial feasibility. But in principle, it's always possible. And when transferred, the data should be provided in a format that is structured, commonly used, and machine readable, meaning that the controller cannot, for example, sabotage your petition by providing the data in a format that really serves for nothing. So that's one very important thing to do. And the idea is more or less that that what we want to do with that, of course, is that we want to ensure interoperability of the data so as that they are really valuable for you and you can bring it with you to someone else that will be able to use those data. Of course, this is quite a risky operation always. So the controller is required to take the necessary measures to guarantee a safe transfer. And this could be done, for example, through data encryption, one-time passports, all the way they want. But this is part of the principles that they need to follow. So, and it's also part of the right to data portability. Then you get the last two ones, just to make sure that I'm not taking too long. One is the right to object, and the other one is the right not to be subject of automated decision making. So that's more or less what we have. Right to object, very simple. The data subject has the right to object to data processing at any time. For example, if you're on a web page and you are blocking cookies, you are doing that, okay? So it is applicable where the legal basis for the processing is the controller's performance of a task carried out in the public interest, or where the processing is based on the controller's legitimate interest, okay? So in these cases, it is mostly when the right to object might apply. In some others, it does not. Okay, so just always keep it in mind. It's also important to keep in mind that the data subject is refrained from objecting when data are processed for scientific or historical research purposes and statistical purposes, or are necessary for the performance of a task carried out for reasons of public interest. Keep it in mind because this is quite important when you are trying to use those data for research. And finally, right not to be subject to an automated decision making. Well, this is very important. Right, is reflected in Article 22 of the GDPR. It's very important because we all know that each and every day, it happens more often that we are being part of a kind of automated decision making, or at least we are being subject of profiling. For example, when you are just watching your TV and Netflix is sending you some recommendations because they are just, they got your profile and they're profiling you, and that's why they are sending you some recommendations. Well, this is not so important in so many ways. It's what we will call a kind of a low risk processing. But in any case, in another situation, that could be very, very much more risky for you. So what the GDPR says is that in principle, the data subject has the right not to be subject to a decision based on automated processing, including profiling. So this could not happen, okay, to you according to the GDPR. In other words, this means that human involvement is warranted. So the point is that it will always be someone, a human being, who's making the decision, even if a kind of artificial intelligence intervenes, if lots of personal data are being processed in the meantime or whatever. But finally, it's you who will keep control on that, and there will be a human being on there. There are three exceptions, however, of the general prohibition of automated decision-making. Namely, whenever the decision is necessary for entering into or performance of a contract between the data subject and the controller, authorized by the EU or an EU member state law, or it is based on the data subject's explicit consent. So as you can see, you are protected, but there are lots of exceptions to this kind of protection. So I think that in the future, we should keep an open eye of what might happen on this, okay? But at least we got that. And finally, we should always keep in mind that where sensitive data are involved, automated decision-making can occur on the condition that the data subject has explicitly consented to it, or where it is necessary for reasons of substantial public interest provided for by EU or member state law. So that's what we have. And finally, an open eye. There are some common restrictions to data subject rights that are included in Article 23 of the GDPR. And these have been included in the GDPR to safeguard some essential objectives, such as, for example, national security, defense, public security, prevention, investigation of criminal penalties, and some other very important things to be done. But those are really, I mean, it's quite easy to understand why this kind of restriction applies. And I don't think that really must be considered as a dramatic restriction of our rights also. But it's good to keep in mind that this exists, okay? And it's very important to consider that rights are not with no limits at all. So I think that more or less, I've told you all that was really necessary to understand regarding the issues that were at stake and the type of things that that this training course was meant to. I really hope that you have enjoyed it. And I really hope that you will be looking forward to interact with us in the Panelfit project in the next days or weeks or months or whatever. We are finishing with the project by the end of April, I mean next month, but we will try to keep updating some things during some time. So I really, I will be delighted if some of you would like to cooperate with us or benefit from whatever we are doing. For more information, please follow the dissemination events that will take place in the next days. Monica will probably send you some information just in case you want to join us. Most of them are online events or hybrid events, so you can really join us at your home. So thank you so much again for your attention,
most
everyone.
of them have already received all the information when registering for the course, so
that's great.
Just in case anyone has missed it, I have copy-pasted the link in the chat.
That's good. So just keep an open eye to your emails and so on, and we will be looking forward to having you with us again whenever you want. Okay. Thank you so much for you all to your attention. I really hope that that was useful for you, and we will we really managed to give you a nice view about the GDPR and some of the most important things that you got there. Thank you. So bye-bye. Have a nice day. Enjoy the rest of the day. Bye-bye. Bye-bye. Bye.